Deep, very serious.
Hi everyone, welcome to Deep Dive True Crime. In this video, we will give you the biggest takeaways from the last pre-trial hearing in the Donna Adelson case. 1. The significance of the defense's motion in limine regarding the new investigation. From watching the hearing, we learned that the impact this new investigation into Donna Adelson has had on the defense's strategy has been huge. The motion in limine, which Ed read for us in full, is highly redacted. The motion seeks to exclude a large number of specific testimony from Grina Bernhardt and Patricia Bird, the two informants. Judge Everett ordered the state to file a written response, addressing each of the specific arguments made by the defense, and then Judge Everett will rule on the motion based on the motion itself and the written response, just like most federal motions are resolved on paper without a hearing. From the hearing and from what Jackie Fulford announced towards the end of the hearing, the impact of Judge Everett's rulings will be huge. The defense could not estimate how long the opening statement would be, or even if they would defer it until after the state presents its case, until the judge issues his rulings. Likewise, the defense could not estimate how long the defense case would take, whether it was going to be 4 or 6 days. It would all depend, according to them, on the judge's rulings on the motion. So we can't really evaluate what is going to happen because everything that is of significance has been sealed, including large portions of that motion. Whatever those two ladies said, those two informants said, must be quite incendiary, because it all remains under seal, likely to avoid negative publicity on the eve of trial, and thus to avoid the need for a change of venue. 2. Donna Adelson's strategy includes having the support of her family and friends in the gallery. When Charles Adelson was tried, there was not one person there to support him, except his lawyers, of course. There was no one waiting in the gallery, hoping for an acquittal, ready to hug him afterwards. As you may recall, Harvey and Donna Adelson agreed not to attend the trial or testify for Charles, in exchange for not being forced to be interviewed by the prosecution in the days ahead of the trial. So the Adelsons opted to prioritize the secrecy of their defense over Harvey and Donna's right to testify, to corroborate Charles' story, and to support him in the gallery. Donna opted for a different strategy. Obviously, the defense has indicated that it wants to use the seats reserved for the family and friends of the defendant in the gallery, and that those family members and friends also want to have access to a special room in the courthouse that will be set up for them to use during breaks. To us, this also signals a potential defense strategy to use character evidence in Donna's defense. Let me explain. Character evidence about the defendant is usually inadmissible at trial, with many exceptions, of course. The state is generally prohibited from introducing evidence of unrelated misconduct of the defendant or bad character of the defendant to make the jury feel that this is a bad person so that she must have done what she's being charged with. Like I said, there are exceptions to all these rules, of course, like, for example, the Williams rule evidence, which we discussed in a prior video, and which has to do with prior misdeeds that have a direct connection to the crime at issue, and that under limited circumstances may be allowed to be introduced as evidence for example, modus operandi, right? If a particular person is charged with a robbery that happened in a particular way, and there's evidence of other robberies that were done in this peculiar individual way by the same person, that evidence of the prior robberies would come in under the Williams rule. The defense has some limitations on how it can use character evidence as well. I expect that Donna will try to present some character evidence to address, for example, the issue of violence. She may have testimony from a close friend that Donna, for example, has a reputation in the community of being peaceful or nonviolent. Any use of character evidence by the defense has a risk because it opens the door to the prosecution. And by opening that door, the prosecution may be able to introduce highly damaging evidence about the defendant's character. If it has any such evidence to rebut her evidence. And it can also engage in cross-examination on those issues and may have things that they can use in the cross-examination after that door has been opened. So, the state is likely to anticipate the potential that Donna will go this way, and it is likely going to be ready for it, not only on cross-examination, but potentially also with rebuttal evidence. 3. The significance of Luis Rivera. As we all know, Luis Rivera is one of the two hitmen. He's the one who flipped and turned state witness first. The other one still hasn't testified and has not cooperated with the state, Sigfredo Garcia. But Luis Rivera has. Now, he did not have any direct contact with any of the Adelsons in anticipation of the hit. But he confirmed through his testimony that all of the information was coming from Catherine McBanua through Sigfredo Garcia. So Catherine would give the information to Sigfredo, and either he would hear it as they were talking, or Sigfredo would tell him that information. The defense revealed a strategy involving Luis Rivera during this hearing, that Donna Adelson will testify regarding her fear of Luis Rivera due to the fact that he was the leader of the South Florida chapter of a powerful gang, the Latin Kings. So, for the defense strategy, it is important for them to get more details about Luis Rivera's involvement in the Latin Kings admitted into evidence. For now, consistent with prior rulings, Judge Everett indicated that he will only allow evidence of Luis Rivera being associated with a gang, generally speaking, but nothing more specific, nothing about him being the leader of the gang or which gang it was and which role he played there. In support of their argument, the defense first made a pretty bad argument regarding the bump operation by the FBI. Although the detective from the FBI who played the role of an associate of Luis Rivera testified that the whole setup of the bump was that he was a member of the Latin Kings, nothing in his testimony suggests that he was dressed in a way that Donna Adelson would recognize as a Latin King, or anything close to that. We have published the bump here on the True Crime a few times, and clearly he never tells Donna or otherwise suggests to Donna during the bump that he is a Latin King. We never heard him mention the Latin Kings at all. Judge Everett quickly caught on to this point, asking the defense how it plans to prove that Donna Adelson knew that Luis Rivera was a Latin King, or thought that he was a Latin King. The defense responded that they would do so through the testimony of Donna Adelson and possibly also through Charles Adelson, who is also listed as a defense witness. The entire discussion introduces a few interesting topics. Let me just finish that point, however. So the conclusion was, by Judge Everett, that, well, if the defense does lay that foundation, right, that Donna Adelson somehow knew that Luis Rivera was a Latin king and that she was afraid of him, then the judge will consider and potentially will allow more specific evidence about Luis Rivera's involvement in the Latin Kings. So that's a decision that the judge will make down the line. All right. And so therefore, what the judge did is that he said that Luis Rivera will remain under the defense subpoena until the end of the trial, giving the defense the option of trying to bring that evidence into the trial later on after the foundation is established through Donna Adelson's or Charles Adelson's or both of their testimony. All right, so the entire discussion that happened at the hearing introduced to me a few interesting topics to think about. When Donna Adelson, the first issue is, when was Donna Adelson supposed to have feared the Latin kings? Because based on Josh Zellman's arguments, it seems that the defense will present evidence that Donna Adelson was afraid of Luis Rivera specifically, particularly because of his role in the Latin kings as being a leader. Mr. Zellman's argument suggests that this was around the time of the bump. However, based on the evidence that we all know so far from several trials, this makes very little sense. Think about it. Charles Adelson testified that he was not aware of who were the extorters who had extorted him through Catherine McManua right after the murder. He testified that Katie wouldn't tell him, and he was himself afraid to ask. So when, according to Charlie, his mom pressed him with questions when he asked her for numerous checks for Catherine McManua from their dental practice, he told Donna about the extortion, but he could not possibly have told Donna about any Latin king's involvement at that time, since at that time he had no idea who Luis Rivera was and what was his involvement in the murder of Dan Markel. The first time that the Adelsons could possibly have become aware of Luis Rivera was after Sigfredo Garcia's arrest, when, on his own, the then chief judge of the Second Judicial Circuit, Judge Jonathan Sjostrom, entered an order unsealing the probable cause affidavit. Or maybe a day or two earlier, when it appears the same judge shared details from the affidavit with Wendy Adelson's then boss, a judge, Adalberto Jordan, of the 11th Circuit Court of Appeals. But that would have been in late May or early June of 2016, and the bump happened more than a month earlier, in April of 2016. And when the bump happened, Luis Rivera's name was not out there. Even when you listen to the recording of Charles Adelson talking to Catherine McManua at Dolce Vita, it sounds as if he doesn't even know who Tato is. Thus, it remains to be seen how the defense is going to try to tie this up. And by the way, about that issue of the Dolce Vita, I don't recall if it was at Dolce Vita or in another one of those recorded phone calls, but at some point he's like, who the heck is Tato? Anyway, it remains to be seen how the defense is going to try to tie this up. How and when did Donna Adelson learn the name Luis Rivera, and how did she learn that he was the leader of the Latin kings? Then, if they cross this hurdle of knowledge, then what are they going to offer as evidence regarding Donna's behavior in regard to her fear? Is that what the defense is going to try to use to explain away Donna's failure to go to the cops in 2016 after the bump? Or even later, after the probable cause affidavit for Sigfredo's arrest was unsealed by Judge Sjostrom? Certainly, the defense is not planning to use this supposed fear of Luis Rivera to explain her trip to Vietnam. Donna already testified about that trip, so she is already committed to a story that does not suggest any fear at all of the Latin kings. Her story was that they were going on a vacation to clear their minds after the horrible and hurtful loss of Charles Adelson at his trial. You can be certain that the prosecution will be all over Donna on cross-examination on all these issues and will point out on cross any and all fallacies in whatever testimony Donna or Charlie give on these issues. They'll likely also have some rebuttal evidence to use against Donna, because if she's going to be testifying about acting in fear, they may be able to come up with evidence of her not acting with fear during those time periods. How about Charles Adelson? Will he really testify? Let us cover that point a little bit. First of all, the defense cannot give Charles Adelson any immunity when they put him on the witness stand. Therefore, if he testifies for Donna, he won't be protected by immunity, and he has pretty much two choices. He can plead the fifth, or he can testify without immunity, but then everything that he says can be used against him at a retrial in his case, if a retrial is ever ordered. Remember, Charles' appeal is still pending, and he still has hopes of a new trial someday, maybe through the appeal, maybe through a post-conviction motion alleging conflict of interest. Who knows? Therefore, we can expect that Charlie will never go on the witness stand to admit his involvement in this murder, but then claim that his mom had nothing to do with it, right? To protect her. He won't make such an admission. Rather, he's likely to stick to the same story he already locked himself into at his trial. If he adds anything new, it won't be anything that can be used against him on retrial if he happens to win his appeal or his post-conviction motion, which will probably be filed if he loses the appeal. Rather, it will be something consistent with that story that he testified to at trial. However, he will be subject to cross-examination, and the prosecutors won't be nice to him, as his mom's counsel is likely to be. Certainly, the safest bet for Charles is to plead the fifth and not risk saying more things that will hurt his future chances, or if he gets a new trial. So he should just not testify for his mom. If the state wanted to call him as a witness, such as during rebuttal, he would be testifying under limited immunity, of course, but he could just refuse to testify under the reasonable assumption that the state wants to use his testimony to convict his mom. So he would probably gladly face any consequences of not testifying, such as being held in contempt of court, or even some punishment through the Department of Corrections, instead of testifying against his mom for the state. There was never much doubt in this case that Donna would testify, like Charlie did. Ultimately, it will be her decision, and she can decide not to testify when the time comes. Who knows? But I think it is pretty obvious that she wants to testify and that she will testify. And what we heard during the final pretrial hearing supports the conclusion that it is very highly likely that Donna Adelson will take the stand and battle it out with the prosecutors. She did poorly on the witness stand during the Arthur hearing when Sarah Dugan was cross-examining her, but it seems that she still plans to testify in spite of that. Here are a few extra insights from the recent developments in this case. Donna's witness list includes several lawyers, including several of her own lawyers, but does not include Dan Roshbaum. So those lawyers listed there include, for example, Tara Kawas, who's Katie's defense attorney, Donna Adelson's own estate planning lawyer, who was there for that infamous, overly recorded, dropped phone call when she was on the phone with Charles after his conviction, and then she thought that the call hung up and she started talking about some other stuff that was highly prejudicial to Donna. So that lawyer is going to be there. We're going to also have Maricel Descalzo. Well, Maricel Descalzo is on the witness list, and Maricel Descalzo was her attorney at that time, was also her attorney as soon as Dan Roshbaum switched to defend Charles Adelson. Donna hired Maricel Descalzo, and she stayed on until the beginning of this case. So the only glaring omission as far as lawyers go, in my opinion, is Dan Roshbaum. He was her lawyer in 2016, right after the release of the probable cause affidavit that suggested that the Adelsons were involved in this murder. And he also consulted with her while he was representing Charles Adelson about whether or not travel to Vietnam would be appropriate. What this tells us is that Donna is unlikely to use as a defense for not reporting the supposed extortion to the cops after the arrest of Sigfredo Garcia and Luis Rivera, or even later after the arrest of Catherine Magbanua, on advice of counsel. This is not too surprising, however, since Charlie didn't go with such a defense either. At Charlie's trial, we surmise that Charlie's version of the events was recently fabricated and that the extortion story was not told to the defense lawyers back in 2016. Otherwise, Charlie would likely have tried to use his own attorney's testimony to disprove that the extortion story was recently fabricated. There were other indicators of that, of course. If the lawyers had been told about the extortion back in 2016 before Catherine Magbanua was arrested, they likely would have done more things to try to preserve evidence of the extortion, including perhaps trying to record Catherine Magbanua, or if they thought that she was a victim, just like Charles, asking Catherine Magbanua to do an affidavit or a recorded interview where she explained everything about this supposed extortion. But they didn't do that. And we think it was because that story was fabricated after the fact. So, we're not saying that a court would have allowed Dan Roshbaum to testify as to such a, to support a defense of advice of counsel. That's not what we're saying. What we're saying is, let me put it this way. A prior consistent statement can sometimes be used to rebut a claim of recent fabrication. But Charles would have a stronger case on that if he had the testimony of friends and family members testifying that Charles told them about the extortion closer to the time when this happened back in 2014, and not after the involvement of the Adelsons as a theory of what happened was released through the probable cause affidavit, because by that time they consulted with lawyers, and whatever they would have said would likely be self-serving if they came up with extortion theory then. Anyway, we wonder whether Donna will have friends who are willing to back up whatever story she will be telling on the witness stand. For those few of you who did deep dives into Donna's calendar with us many, many months ago, probably over a year ago, you may remember that long before this new investigation came into place, there was evidence on that calendar suggesting that Donna was actively trying to talk to witnesses or having others talk to witnesses to see whether they would help out Charles Adelson. Can't tell you from the calendar entries whether or not that was some kind of tampering, but it is suggestive that she was trying to influence testimony. There's even markations on that calendar about somebody who's willing to help Charlie at trial. It would seem that Donna's defense will be that Charlie told her that he was being extorted and that she helped him out in the way that he requested, that she believed that Charlie was not involved, but regardless, she was not involved for sure. Not in the murder. She did what she did afterwards regarding paying Kitty as a protective mother, worried for her son, worried for all of them, who were all being extorted. Not because she was involved in murder. And then, about the most important piece of the evidence for the state, the recording after the bump where she told Charles the issue that she needed to talk to him about was about the two of us right after the bump. She'll likely say that she considered it to be about the two of them because she had been helping Charlie with the extortion problem. She had made payments to Catherine McVenua. Whether anyone will believe her in light of all of the other evidence does not matter. The question is whether the jury will believe her based on all of the evidence that the state can successfully introduce at her trial. All right. If you like this video and want us to share additional insights, you know what to do. Thanks for watching Deep Dive True Crime.
Deep. Very serious.
There are two motions of limine in the file in the state of Florida versus Donna Adelson case. One is not visible at all. The other one is highly redacted. Ed is doing a reading of the highly redacted one, so y'all can evaluate for yourselves with the caveat that we don't have everything that the motion says, and so therefore it is difficult to evaluate it. But at least we can see their arguments. Here we go.
Defendant's motion in limine, new investigation, redacted copy. Defendant, Donna Adelson, by and through her undersigned counsel and pursuant to sections 90.403 and 90.404 paren 2 Florida statutes, requests that this honorable court exclude and or limit introduction of evidence from the new investigation and in support thereof states as follows. 1. Mrs. Adelson has been indicted in this case with one count of first-degree murder, one count of conspiracy to commit first-degree murder, and one count of solicitation of first-degree murder. 2. On April 7, 2025, the state disclosed the existence of a new investigation that began after a jailhouse informant contacted the state in December 2024. The first informant's information led to a second informant. Although both informants made statements which were consistent on a limited basis, the vast majority of the first informant's claims were either established to be false or could not be corroborated. 3. By this motion, Mrs. Adelson moves to exclude evidence from the new investigation. 4. During her interviews, redacted, or otherwise should be inadmissible pursuant to Section 90.403 Florida statutes. 5. Alternatively, should the court find any of the allegations to be admissible under 90.404 or otherwise, Mrs. Adelson requests the court limit admission of evidence to that which satisfies the balancing test required by Section 90.403 Florida statutes. Statement of facts. 6. Ms. Bernhardt was interviewed on December 20, 2024, January 13, 2025, and January 29, 2025, and February 11, 2025. 7. For example, redacted. 8. Redacted. 9. Redacted. 10. Redacted. 11. Redacted. The new investigation failed to produce any evidence to corroborate these claims. 12. Redacted. The new investigation failed to uncover any evidence to corroborate this claim. 13. Redacted. The new investigation failed to cover any evidence to corroborate this claim. 14. Redacted. The new investigation failed to uncover any evidence to corroborate this claim. 15. Redacted. The new investigation failed to uncover any evidence to corroborate these claims. 16. Redacted. The new investigation failed to uncover any evidence to corroborate this claim. 17. Redacted. The new investigation failed to uncover any evidence to corroborate these claims. 18. Redacted. The new investigation failed to uncover any evidence to corroborate this claim. 19. Redacted. The new investigation failed to uncover any evidence to corroborate this claim. 20. Redacted. These alleged ties could not be verified by law enforcement. Redacted. 21. Redacted. The new investigation failed to uncover any evidence to corroborate this claim. 22. Finally, redacted. The new investigation failed to uncover any evidence to corroborate these claims. 23. On April 2, 2025, Patricia Byrd was interviewed by law enforcement. During this interview, Byrd made numerous claims about Mrs. Adelson. The undersigned deposed Byrd on January 17, 2025. 24. Redacted. 25. Redacted. 26. Redacted. The new investigation failed to uncover any evidence to corroborate this claim. 27. Byrd confirmed, telling the investigator Magbonawa was arrogant and manipulative, and that Magbonawa got special benefits from guards. She also said Magbonawa told the whole pod her boyfriend paid for her boob job. Redacted. However, the original investigation failed to produce any evidence to corroborate that, redacted, but suggested Magbonawa paid for the boob job, at least in part, from the money she received on July 18, 2014. 28. Redacted. 29. Redacted. 30. Significantly redacted. Discussion. Evidence is not admissible as Williams Rule evidence. 31. Section 90.404(2) Florida statutes, titled Other Crimes, Wrongs, or Acts, is the guidepost for introduction of this type of evidence against a defendant. It states in relevant part, A. Similar fact evidence of other crimes, wrongs, or acts is admissible when relevant to prove a material fact in issue, including, but not limited to, proof of motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident, but it is inadmissible when the evidence is relevant solely to prove bad character or propensity. 32. Evidence of any crime committed by a defendant other than the crime for which the defendant is on trial is inadmissible in a criminal case when its sole relevance is to attack the character of the defendant. Cornetzer v. State. See also Dawkins v. State, Garvey v. State, J.P. v. State, Finkley v. State. 33. Collateral crime evidence is admissible if 1. It is relevant and has a high probative value in proving some material fact at issue in the instant case. 2. Its sole purpose is not to show the bad character of the accused. 3. Its sole purpose is not to show the propensity of the accused to commit the type of crime charged. And 4. Its admission is not precluded by some other specific exception or rule of exclusion. Copshaw v. State. 34. Before admitting evidence of collateral crimes, a court must conduct a 4-part inquiry determining whether 1. There is sufficient evidence that the defendant committed the collateral crime. 2. The collateral crime meets the necessary similarity requirements necessary to be relevant. 3. The collateral crime is not too remote so as to diminish relevance. And 4. The probative value of the collateral crime substantially outweighs the prejudicial effect. Copshaw, also Peterson v. State. 35. The trial court must find that the state proved the defendant committed the collateral crimes by clear and convincing evidence before allowing the jury to hear the evidence. Copshow, also McLean v. State, Smith v. State. As a condition precedent to admission of the evidence, the trial court was required to determine that there was clear and convincing proof that the appellant committed the prior abuse. 36. Clear and convincing evidence has been defined as evidence that is precise, explicit, lacking in confusion, and of such weight that it produces a firm belief without hesitation about the matter in issue. 37. To be clear and convincing, the evidence cannot be indecisive, confused, or contradictory. In Re Davy, quoting, clear and convincing evidence requires that the evidence must be found to be credible. The facts to which the witnesses testify must be distinctly remembered. The testimony must be precise and explicit, and the witnesses must be lacking in confusion as to the facts in issue. The evidence must be of such weight that it produces in the mind of the trier of fact a firm belief or conviction, without hesitancy, as to the truth of the allegations to be established. Slumowitz v. Walker. 38. A critical aspect of the test of admissibility under Section 90.404(2)(a) is whether such evidence tends to prove a material fact issue that is in dispute. If there is no bona fide dispute over a material fact that the similar fact evidence is offered to prove, then the probative value of such evidence necessarily has significantly less importance than its prejudicial effect, and the evidence should be excluded under Section 90.403, Thomas v. State. 39. Therefore, this evidence is only admissible to prove motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident. Even if the allegations tangentially touch upon one of the exceptions, introducing collateral crime evidence is inherently prejudicial and creates the risk that a conviction will be based on the defendant's bad character or propensity to commit crimes rather than on proof that he or she committed the charged offenses. Hearing v. State, Titel v. State. Since the argument against introduction of collateral crime evidence is relevant even if it falls into one of the exceptions making its introduction relevant, Section 90.403 still applies. See Butler v. State. When such irrelevant evidence is admitted, it is presumed harmful error because of the danger that a jury will take the bad character or propensity to crime thus demonstrated as evidence of guilt of the crime charged, Consalvo v. State, as revised on denial of rehearing, Pope v. State, Strait v. State. 41. Even if the state could establish clear and convincing evidence to reduce the risk that the jury will not convict based on the defendant's bad character, the state cannot make the collateral act a feature of the trial. See Stevenson v. State. The prosecution should not go too far in introducing evidence of other crimes. The state should not be allowed to go so far as to make the collateral crime a feature instead of an incident, quoting Randolph v. State. Finally, at the time the evidence is admitted, the trial court shall, if requested, charge the jury on the limited purpose for which the evidence is received and is to be considered. Subsection 90.404(2)(c)(2) Florida statutes. See also Robertson. This cautionary instruction shall be repeated to the jury at the close of evidence. See subsection 90.404(2)(c)(2) Florida statutes and McLean v. State. 42. Significantly, the state has already conceded the allegations do not rise to the level of probable cause, as no new charges are being pursued, let alone clear and convincing evidence. With this concession previously made on the record on April 30th, 2025, the state has also conceded it would be unable to establish the clear and convincing evidence necessary for admission of this evidence under Section 90.404. 43. As a result, the testimony of Bernhardt and Byrd is not admissible under Section 90.404 Florida statutes. Evidence is not admissible as consciousness of guilt. 44. For this discussion, there are two separate issues to analyze. Redacted. 45. Redacted. Killed. 46. Additionally, the undersigned acknowledges redacted. 47. Thus, even if Bernhardt's claims are truthful, redacted. 48. Absent evidence, redacted. 49. Based on this discussion, redacted are inadmissible. 50. This brings us to the second issue, redacted. 51. The undersigned concedes that generally speaking, such evidence is admissible, State v. Rodriguez, citing Manuel v. State. 52. However, the evidence must still be A, truthful, and B, is probative value not be substantially outweighed by the danger of unfair prejudice, confusion of issues, or misleading the jury. 53. It is the undersigned's position that the claims made by Bernhardt and Byrd are false. It is axiomatic that no party is permitted to present false or perjured evidence. Aside from innocent details, there is no evidence that corroborates their substantive claims. 54. Additionally, Mrs. Adelson objects to Bernhardt testifying absent an opportunity to depose her. The state waited to disclose the new investigation until about 5 weeks after they last had contact with Bernhardt and 3 weeks after a warrant was issued for Bernhardt's arrest for violating probation in case number 2022 CF 347, as well as an order to show cause pending in 2024 CF 2714. The order to show cause was not issued until April 3, 2025. Evidence is not inextricably intertwined. 55. The concept of inextricably intertwined evidence removes evidence from consideration of admissibility under the Williams Rule. 56. The Honorable Milton Hirsch stated that at common law, inextricably intertwined evidence is defined as, quote, other crimes evidence which must be indivisible from the evidence of the charged crimes, such that the tale of the charged offenses could not be told without relating the evidence of the uncharged offenses. Hirsch. The, quote, this newborn babe and infant Hercules, the doctrine of inextricably intertwined evidence in Florida's drug wars. 57. As recognized in McGee v. State, evidence of uncharged crimes which are inseparable from the crime charged, or evidence which is inextricably intertwined with the crime charged, is not Williams Rule evidence. It is admissible under Section 90.402 because it is a relevant and inseparable part of the act which is in issue. It is necessary to admit the evidence to adequately describe the deed. Griffin v. State. Quoting Charles W. Earhart, Florida Evidence, subsection 404.17. 58. The Florida Supreme Court has cogently described the admission of collateral crime evidence as inextricably intertwined in the following manner. Occasionally, when proving the elements of a crime, it becomes necessary to admit evidence of other bad conduct to adequately describe the offense or connect the elements of the offense because the charged offense and the other conduct are significantly linked in time and circumstance. In other words, this evidence is admissible because it is a relevant and interwoven part of the conduct that is at issue. Where it is impossible to give a complete or intelligent account of the criminal episode without reference to other uncharged crimes or bad conduct, such evidence may be used to cast light on the primary crime or elements of the crime at issue. However, when there is a clear break between the prior conduct and the charged conduct, or it is not necessary to describe the charged conduct by describing the prior conduct, evidence of the prior conduct is not admissible on this theory. Wright v. State. 59. Such evidence or other bad conduct on the part of the defendant is admissible where its presentation is part of the, quote, general context in which the criminal action occurred. Hall v. State. See also Griffin v. State. holding that testimony regarding first-degree murder defendant's theft of the murder weapon was inextricably intertwined and was necessary to establish the entire context out of which the crime arose. The Florida Supreme Court stated as follows regarding the proper application of the inextricably intertwined doctrine. Collateral crimes evidence is inextricably intertwined if the evidence is necessary to 1. Adequately describe the deed, 2. Provide an intelligent account of the crimes charged, 3. Establish the entire context out of which the charged crimes arose, or 4. Adequately describe the events leading up to the charged crimes. 60. In Ballard, the court held that evidence of the defendant's inappropriate sexual conduct with the murder victim prior to the killing was relevant to show motive and was inextricably intertwined with the testimony needed to establish the crime. Professor Earhart explained that inextricably intertwined evidence is not admitted because it shows the commission of other crimes or because it bears on character, but rather because it is a relevant and inseparable part of the act which is in issue. Charles W. Earhart, Florida Evidence. 61. However, evidence of uncharged misconduct is considered inextricably intertwined with the charged offense only if excluding that evidence would have left a chronological and conceptual void in the state's case, United States v. Beretta, or if it is necessary to avoid the confusion which would be caused by its exclusion, and then only after balancing the prejudicial effect of its inclusion, Pope v. State. Further, care must be taken to assure that prior crimes are not received in evidence solely because they precede or closely follow the crime charged. The purpose of this use of such evidence is to complete a picture, not to paint another, and to provide context and meaning to the central events in issue. Other offenses are not useful to such ends should be excluded no matter how close in time or place. Louisel and Mueller, Federal Evidence. See also United States v. Echeverry, asserting that inextricably intertwined doctrines should be carefully circumscribed and should be applied narrowly to avoid the overly broad so-called res geste exception. 62. Thus, when there is a clear break between the uncharged conduct and the charged conduct, or it is not necessary to describe the charged conduct by describing the uncharged conduct, evidence of the uncharged conduct is not admissible on this theory. Charles W. Earhart, Florida Evidence. 63. In Holmes v. State, the defendant shot and killed the victim, but argued that he acted in self-defense. Defense counsel filed a motion in limine seeking to exclude evidence that the defendant sold drugs at any point, particularly to the state's witness who observed the killing, or that the defendant was attempting to collect a drug debt when the shooting occurred. The trial court denied the motion in limine, and the evidence was presented at trial. On appeal, this court held that the evidence showed a continuing chain of chronological events without which an intelligent account of the criminal episode could not have been given and was therefore admissible. 64. In Scott v. State, the appellant was convicted of felony murder by aggravated child abuse. Defense counsel filed a motion in limine seeking to exclude testimony that the child suffered a broken arm and leg approximately 1 month prior to his death. The state argued that this evidence was inextricably intertwined with the charged crime, and the trial court admitted it on that theory. The court held that the evidence was improperly admitted as inextricably intertwined because the broken bones were not related to the cause of death and the events happened a month prior to the child's death. In Scott, the state had failed to meet the notice requirements for the introduction of similar fact evidence, and that is why the inextricably intertwined argument was presented. The court found that evidence of the victim's broken bones, which did not contribute to the victim's cause of death, was inadmissible under both an inextricably intertwined theory and a similar fact evidence theory. 65. The allegations claimed by Bernhardt and Bird are not necessary for any of the purposes outlined in Ballard to 1. Adequately describe the deed, 2. Provide an intelligent account of the crimes charged, 3. Establish the entire context out of which the charged crimes arose, or 4. Adequately describe the events leading up to the charged crimes. 66. As the Florida Supreme Court stated in Wright, when there is a clear break between the prior conduct and the charged conduct, or it is not necessary to describe the charged conduct by describing the prior conduct, evidence of the prior conduct is not admissible on this theory. 67. Moreover, its admission is unnecessary to establish a material element of the crimes for which Mrs. Adelson is under indictment. 68. As a result, admission of such evidence as inextricably intertwined would be improper and should be excluded on that basis as well. The vast majority of claims do not survive a 90.403 analysis. 69. The underside concedes that, redacted, the remainder of Bird's testimony is likely admissible. 70. The same is not true concerning the varied claims made by Bernhardt during her multiple interviews with law enforcement. If she is located for trial, and only for those claims which are relevant, the probative value of almost all her claims is substantially outweighed by their prejudicial effect. 71. Redacted. 72. The only statements from Bernhardt which arguably survive a balancing test, redacted. Wherefore, the defendant, Donna Adelson, respectfully requests that this honorable court grant this motion in limine, enter an order prohibiting the state from introducing evidence from the new investigation, or, alternatively, limiting admission of the new investigation as set forth, and for such further relief as is just and proper. Signed, Jackie Fulford, Joshua D. Zellman.
Thank you for watching today's deep dive. If you found this case interesting or have any thoughts, feel free to leave a comment below. Remember, this community thrives on smart and respectful discussion. Don't forget to like, subscribe, and hit the bell to stay on track with our new case videos. We cover new details, court hearings, interviews, interrogations, and more. This is Maya with Deep Dive True Crime and Mentor Lawyer Justice Network, and I'll see you all in the next video.